Okay, hello friends. We welcome you to this webinar. This is the third webinar in the series towards old pension scheme, and there was a High Court judgment recently on a matter of a teacher wanting from NPS to OPS. So Avinash, in fact, forwarded us the court judgment, and so Avinash also doesn't require any introduction here because our last webinar was with Avinash. But yet Avinash is in School of Social Sciences, JNU, and is a former secretary JNUTA. So he's continuously has been part of Fed Kuta movement, JNUTA movement. Avinash, we welcome you to this webinar, and we will want you to help us to read that judgment, because it is likely that it will help a large number of teachers in Delhi University who may fall in that category of relief. Welcome, Avinash. You can start.
Thank you, Comrade Ava. It is indeed a pleasure always coming here and talking. See the point which we thought when we were discussing with Abha, and I also thank Vandana who actually first forwarded me, and then subsequently I had sent this to you, Abha, and then we decided that we should have this workshop. The point which is very important, if I continue from what we had discussed last time, is that if you remember, we had said that there was a single judge order from Delhi High Court by Justice Jyoti Singh, which had actually kind of defined in a very succinct way who should be classified under the new, if at all there is something called as new pension scheme, and isn't order, not just in one case but in several cases that were pending since 2018, 19, even 15. In fact, I had also pointed out that that between her first order when she gave this and the second order when she gave, there was a change in the situation where Delhi University has actually appealed against the first order in a divisional bench, filing a leave petition, so LPA. And that was something which in the later judgments, Jyoti Singh had actually taken that into consideration and had recorded that in the order. When the university appealed it, the divisional bench and the LPA, the court has actually not given a stay order of my previous orders, and therefore I am at a liberty to continue and to understand this, that my recent order has not been stayed, and therefore I'm giving all the subsequent orders which giving relief to all the subsequent people who are cases which are pending and people who are approaching me new. In fact, I had also quoted in the previous discussion Delhi University. Yeah, was there a snag in between because my video was freezed? Am I audible? Right. So the point I was trying to make, that this that the university had actually appealed against the single judge order. Um, and filed a leave petition. One petition was filed by an employee from Jamia, and there, when this was being raised again, the university had said that this is already under challenge. And once again, Jyoti Singh herself had said that okay, we are aware of that, but since that order has not been stayed, therefore, I'm of the opinion that the order which I have given in my previous orders granting OPS to in certain cases, based on the definition of the new, that who can be defined as new, still active, and therefore I'm giving. So even in Jamia case, she gave that order. Now, Therefore, this was a very important order which came by the division bench by the dismissing the late petition. Now, if you read the petition here, it might sound to you that there has been a lot of emphasis given on the on the respondent number one, which is the first case, case of Ravindra Narayan Mishra from Khalsa College. There a lot of discussion is based on that, and the petition has been dismissed on the basis that the court had observed that the respondent number one, which is the university, actually has made anonymous kind of appeal and is placing incorrect facts, which is kind of very clear when they look at the affidavits which the court asked them to submit. And based on that, it has not only said that the facts were anonymous and they were wrong, placed by the university, but it has also imposed a penalty, which because in the earlier hearing on April 29th, this order is May 14, which is the final order. There was an order on April 29 where the university was warned that if you are actually saying anything false, then we will impose penalty on you. And when the just a day before when this matter was listed, when the university filed, it was very clear that the university had given false information, and therefore the court came heavily on the university and has actually imposed a cost on the university of 50,000 to be paid to the appellant respondent number one. But you will also note that the subsequent line, which says that the pending application is also disposed as being infructuous. Now, that's a very important one because it's not just saying that what the university had done, that it actually used wrong information to make its point heard and to challenge that order by the single judge. Now, once therefore the court was of the opinion, the division bench was of the opinion that this present appeal is itself infructuous because you do not have any substance. They did not take any time to dismiss it, and that's a very important message which has been given. Is that now not only that the petition has been dismissed, but the petition has been dismissed with a cost. Now it's something which is much more than mere a dismissal of the petition, and therefore the university will have to rethink about it. The second, so this is the effective part of the order. The second point which I wanted to emphasize, that if you will look at this order, probably there will be an assumption that there is a overemphasis on the temporary post, that that he was appointed on a temporary vacancy and all of it, giving an impression that if you have any other nomenclature like ad hoc or any other sort of nomenclature that you may have, then it probably might not. But actually, that is not true. And I am giving you another judgment by the single judge, again, Justice Jyotir Singh from Delhi High Court. This is a case of a daily wage worker. The case of Jamia was also of almost a daily wage worker who was appointed on a daily wage as his computer operator. Here, the JNU's case, which he has given, he was a daily wage worker working, on muster roll, who was made permanent much later, much later than 2004. In that order, it is very clearly written. The language is same, and I'm going to read from that so that it becomes very clear. Because you have noted that Jyoti Singh had clearly said in her order in all of these cases, wherever she gave that relief, that she had come to irresistible conclusion. Right now, that's a very interesting, adjective to say and to remark. And therefore, in this case also, which is a case of a daily wager, she has said it in her order that this court comes to the irresistible conclusion that entire service of the petitioners from the date of initial appointments on, and I'm emphasizing, daily wages, oblique, ad hoc, oblique, temporary basis. So there is absolutely no distinction in the nomenclature. If you are appointed in a position prior to 2004 and you continue not exactly, not only in the same institution, in the same college, but even if the institution has changed, even if you have gone into another institution, that is also that's not that's not compulsory. I mean, that's not going to affect your judgment. Uh, so whether it is daily wage or ad hoc or temporary basis, till the date of permanent appointment regulation, they shall be counted for the purpose of the pension as qualifying service, and they should be put under the old pension scheme. Now, in this one, Jyoti Singh has also taken the help of a court order which I had quoted earlier, which was the Supreme Court order by Justice Ravindra Bhatt in August 2024 last year, where he had given, if I'm not wrong, is 24 or 23? Just hold on. Sorry, August 2023. That was once again the case of state of Himachal Pradesh versus Sheila Devi. Sheila Devi had actually got a the relief from the tribunal and the High Court, and then that the state of Himachal Pradesh had challenged it in the Supreme Court. Once again, a case of daily wager, and there the Supreme Court had accepted that irrespective of what position you are appointed in, if you are appointed in a job which is later on regularized, irrespective of what your position, how your nomenclature, and how you are temporary, wage labour, or ad hoc, you would be considered as qualifying to be in the old pension as old employee and not a new employee, because that's very, very crucial. So I just wanted to clarify these three important matters before us, that it is crystal clear that who can be counted as new. In fact, I also wanted to say that in the case of Jamia, this petition had arisen from the fact when recent order of the ministry had come that though you have a one-time choice to go to if you were appointed sometime earlier. That person was appointed in 87, and he had crossed the deadline. There was a deadline given some date in November 2020, and he could not apply before that. He applied after it, and once again, therefore, the court had observed that even if he had missed that deadline, you must consider giving him the option of opting into your OPS. So that's something which is very, very important in more than one way. Delhi High Court, Supreme Court, and many other courts, because these judgments are based not just on Delhi High Court and Supreme Court. I had quoted the Punjab High Court judgment. I had quoted the Madras High Court, which is all quoted in the Jyota Singh's judgment, and several other judgments, which is the even Supreme Court actually is using that. So, in many words, they have clearly said that who could be considered as new. Therefore, all those appointments, who all those colleagues and comrades who have been teaching for so long, but were only regularized after 2004, uh, has to be considered an OPS. It is altogether different matter that we do not want to restrict our fight only to for these reliefs. We want to take it further for all. And the recent UPS and NPS again is a matter that we will be discussing, and we have to take that forward. But as far as these cases are concerned, I think it is the right time for all of us to collectively, put pressure on the university through representations, through our letters, through associations, whether it is JUTA writing, FedCuta writing, whether it is individual staff associations writing from colleges, pressurizing your governing body, also giving this court order and saying that this is now a settled matter, because there is a fine imposed on the university to represent us wrongly, and you have absolutely no way that you cannot do this. So please, devise a mechanism through which collectively this can be done. That's really very important. I just wanted to make these points clear, and if there are any queries and questions, then we can discuss that.
Um, थैंक्स अविनाश, मुझे लगता है ये जो तुमने एंड में बताया कि डेली वेजर को भी ओपीएस के लिए कंसिडर किया गया, आई थिंक इफ यू कैन शेयर दो सुप्रीम कोर्ट जजमेंट्स,
हाँ,
then a large number, because appointments were not happening in DU, a large number were actually working on ad hoc basis during the before 2004, I mean, and they became permanent
yeah,
subsequently in 2005, 2006. So
yeah,
if they have been working without a break, I mean, in the sense that they did not leave a job, but suppose they continued to work from say 2000 or 2001 and crossed 2004 and then became subsequently permanent, I
yeah.
think all of them should apply
Yes,
for. So, Acha, the other thing is, I just want to understand for myself that UPS has been just gazetted.
yeah,
Okay, so surely for in the next executive councils or through the UGC, a letter will come for the universities to adopt it also, and then it will be adopted, and then teachers will be asked whether they want to be in UPS or NPS.
yeah.
So this means that our work for OPS 1 should start now. And if the UPS come and we go for UPS, will it be held against our going for asking for OPS? Or how will that be considered?
No, I don't think that that is. I mean, see, asking for I mean, that's why it is important that all these matters be immediately taken up, and all individuals, whosoever can, must make a representation, stating this that we have already said this based on this court order, that our cases are pending. So unless that is cleared, you cannot. In fact, one can think of possibly talking to lawyers about how to, situate
Club
this.
this.
Yes, that how this can be used. Maybe if there is a need for repetition, about first clarify on this, because people are waiting to hear from the university that why, when the Supreme Court, when the High Courts, and particularly Delhi High Court has given for Delhi University that all those people who have previous service shall be counted. How can you keep it pending for all when they have dismissed even the litigation? So an immediate intervention there is very much needed from our side to pressurize the university to come clean. Now let us be very clear. One thing that Jyota Singh had made it, very very importantly, she had noted um, that the first time when the universities have started this letter. I mean, uh, yeah, I mean, see, the point is that the legal right to shift to OPS doesn't even go. I mean, whether, and that could actually, what, this is an afterthought. And that's why probably the reason the government is changing just the nomenclature from new pension scheme to unified pension scheme, because there is a lot of emphasis being put on who is new, and most of the court orders are coming on it. Now, once this is becomes unified, then the whole question will become more fuzzy. So, I mean, I'm just thinking through. So that's what I was suggesting, that in between, before it gets notified by the UGC to the institutions, Gazette notification had actually become, I mean, it has been more than 2 months now, but it has not been extended to the university, teaching, cadres. The reason is that, as you know, there are more complexities, and even the government knows this very clearly. Now, I was at a point where I had stopped, where I was interrupted. Is that, in the order it was very clearly mentioned, which has been noted with great care by Justice Jyoti Singh, is that she has said that it must be noted in some cases that until 2014, when this university order of May 19, 20, 23rd June 2014 order came, all many petitioners actually were being given old pension scheme. Even I recall discussing with Vandana that she was also part of that, and she was given. It was only after time after 2014, and that date is very important because that tells you about also the regime change. So 20 this university sends an order on 23rd of June 2014, and I think we need to emphasize that. It comes only in 2014 that all those people who were actually earlier placed, that has been taken away by them, despite several governing bodies, despite several colleges writing in favor of that, and the university was not accepting. So that's something which is very important for us. At this point in time, when this petition has been dismissed, and we have a scope that we can collectively emphasize that now this matter should be treated as done and dusted. That is a new settled one, that it should be considered. All those people who have been teaching prior to 2004 must be considered as part of the old pension scheme. And I gave you the order, and I'll share it with it, both the Supreme Court order and the Delhi High Court order, where this is extended not just to teaching positions like ad hoc and temporary, but also to the wage workers, wage laborers, right? I had said it there. There is Supreme Court order. I'll send you the PDF of that. There's also a Delhi High Court order where the Supreme Court order has been also quoted. The Supreme Court order came in August 2023 by Justice Ravindra Bhatt, and the High Court order is in 24. Again, it's the case of JNU, where a daily wage worker in JNU had gone, saying that he was appointed in 2001 too, but made permanent much later, and he has also got that. Uh, in that case, Justice Jyoti Singh has quoted it very clearly that it is they have come to irresistible conclusion that everyone, whether it is wage laborer, whether it is ad hoc or temporary, must be considered as not a new entrant but an old one, and must be considered in the OPS. Yeah. Yeah, Vandana's, Vandana, you had asked me as this. So, of course, I think what is important in your case is that you were also given, you were denied the rights after 2014 when this letter came. And then you were told that, as per the order, we will withdraw, and then you will be put under NPS. So this is an error which the university has made. You are only suffering because of the error that university made at the first place. And of course, you made a choice depending upon the time when you were retiring. I do not see that as any reason for being a reason which kind of restricts your right to ask that, as per these orders, you have already written to the governing to the college. The college has said that they have forwarded. I think it is important that we follow up with the university now that the university has been forced to pay a fine for making mis- you know putting misleading us, misinforming the court. The university has been fined. They have been asked to pay a cost of 50,000 to the petitioner. So that will actually teach them a lesson, at least in the sense that they will not say anything which is misinformed, which is wrong. Although they don't learn from these things, but we expect that they would, and therefore it is important that we emphasize on this point.
Thank you, Avinash. My query is now, I think JNUTA should, collectively respond to our cases or tell us to, we should represent our cases to DU collectively. Because when I wrote a representation to my college, they are not even answering my mail. And they are not going to listen. Even if I talk to staff association, no one has time to listen to me. How to go about it now?
Yeah, no, absolutely, you're right. The JNUTA must, and JNUTA, I think you can all collectively write to JNUTA and ask for it. But now, suppose given the fact that it does not want to take because it is a political question, it does not want to. Then even then we have our rights. I mean, I think DPF and ABBA should take the lead and write to colleges, write to staff associations that this order has come. So anyone who is eligible must immediately write to the university, and the university also write to the university that this is clear now that all those who are into the service, whether ad hoc, temporary, whatever position, it is unrefutable that they are all part of the old pension scheme. Whenever you might have regularized, there are ample evidence, ample things to establish that they are not part of the old pension scheme, and therefore they must be brought into the old pension scheme. I think we'll have to strategize at both levels.
Yeah, so Avinash, I think, Vanna, I don't think so that we need to wait for the response of the authority. That will never come. But I think before we go to court, we have to exhaust that we went up to the university, all levels. So I think as individuals, what we can do is that based on your, Avinash, you give us those judgments again, which are important. And if you can, in a PDF, also mark the important sentences which we can include in our representations, then we will quote the judgment and also the relevant parts. We can make a prototype of the representation we can give to the principal, then to the dean colleges, then to the vice chancellor, so that in a 3 months time, when we exhaust this, then friends can go to the court together. So I think we can make a group which can does it. Of course, when later at the later stage, maybe if we are able to move Duta on the question, it's one thing. But I think it is because it is also, in some sense, our own cases that we will have to follow, rather than just Duta writing or something. Will I don't think so that will hold so much in the court as us doing it for ourselves first.
Yes, yes, absolutely true. That is no denial of it, because that's what your jurisprudence says, that your rights are individuals and the state can be represented as a class. So
So, but what
that's very, very
Kuta can do is that while Duta is, Malab, we will try to move Duta, and I think once our, people who are affected party, people who can see, hope to get justice through these judgments, if they come together, maybe Duta will be moved. But apart from that, maybe FedKuta can write to all its unions,
yeah,
including Duta,
yeah,
saying that several teachers may have taught in these capacities and these judgments may help.
yeah,
So associations may try to do it. So maybe.
absolutely.
Is this thing about I asked about UPS. We are not opting for UPS. That, but then the point is that we should all now begin to collectively start with our petitions. Howsoever many number of people wish to join. Is that how it should work?
Yeah, I think so.
Yeah,
Huh.
yeah, yeah, please.
Because
Yeah,
we have not, Malab, if UPS will come from NPS, we can jump to UPS. But still, from UPS, we can try to say that now, even when we have this, but our right for OPS is saved
yeah,
through these judgments, and then go to OPS.
yeah.
Malab, even if suppose.
Isn't UPS worse than NPS?
Yeah, 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 absolutely. Especially for
Can
those who
we
have
can
lawless
we
services,
can
it
we
is.
can we not give the college option? We do not
Yeah,
want
yeah,
to
yeah.
opt for
You can stay in
UPS.
NPS. Yes, yes, absolutely.
See, why I am asking is there are a few of us who are trying to get into this, and we've written a collective petition for this. So we were only waiting for these judgments, which Avinash you're talking about, and we were only waiting for these judgments to come. Now that everything is there, we were told to wait till the 15th of May. So now it is the end of this month. So now I think the process of our sending the collective petition should begin now.
Yeah, yeah. So I'll share all the judgments which I have mentioned, and you will have all the information with you. June may
Unless it
continue.
happens in
Till
the
then, we can try to write to the university saying that now that the LP has been dismissed, I think the university must take a call and they must issue an order saying that we all those who had joined prior to 2004 and been sort of serving since 2000 for long should be admitted under OPS.
Avinash, I'm sorry, I'm the only one speaking, and I'm sorry कि मैं इसको continue करवा रही हूँ meeting को, लेकिन हमने in my college is अदिति महाविद्यालय, तो हमने अपने कॉलेज में we had written a letter to the principal and those letters had subsequently gone to the university. लेकिन यूनिवर्सिटी से मेरे कॉलेज के नॉन टीचिंग मेथड यूनिवर्सिटी से कोई रिस्पॉन्स नहीं आया या वो लेटर्स वापस आ गए. हमें हमारी वो लेटर्स का कोई स्टेटस क्या है हमें कुछ पता ही नहीं है. वी हैव नो क्लू. This we did last year, yeah, last year I think.
Yeah. No, I mean, even if we do not have any information, it is pursuant on us to send one more reminder saying that there is this High Court order. Now that the LP has been dismissed, please consider that and give us a immediate reply on this. I think
तो
that's
हम मतलब अपनी लेटर्स को दोबारा देके इनके साथ ये सारे ऑर्डर लगा के और हम इनको कहें कि अब हम परस्यू करें.
absolutely.
Dr. Avinash, if I would give, if I could come in here, I just want you to clarify once again that
You can mute me.
I have been a part of the university system since 2002. I've worked as an ad hoc from 2002 to 5, and thereafter got permanent in 2005 February. So I think missed the thing by about just a few months. So does the judgment now say that even I would be eligible for the OPS?
Yes, absolutely, very clear. That's what my whole emphasis was.
I lost the connection in between. So
sorry.
I lost the connection in between, and when I rejoined, the people were in the process of rejoining, so I missed quite some bit of the conversation actually.
Yeah, no, I will read you the judgment by the Delhi High Court. This is a judgment of a JNU employee who was a daily wager.
All right.
Appointed much earlier, and the judgment is very clearly said that irrespective of whether he was appointed as a daily wage or ad hoc or temporary, and and the Supreme Court judgment also says that if you are appointed prior to 2004, whether it is ad hoc or daily wage or any other position, everyone is eligible for.
So there are a couple of time points where there is a break of about 2-3 days. That works, right? Because it was ad hoc.
That's absolutely okay, because see, ad hoc of course will be always have a break. That's a technical point, and that is what the university, you are not responsible for that break. The university in which you have been contributing substantively, the court looks at that whether you are giving a substantive contribution or not. Now that 1 day break does not make you a non-substantive person, because you have taught for the whole year, for the whole thing. You have checked scripts and everything. So it is about the substantive contribution made to that institution. Right. So whichever capacity you have, you are getting a monthly salary which is equivalent. You were taken through a process which is the same as others. So therefore, there is no question of ad hoc not being part of this. And I wrote it from the judgment, and I'll share that judgment with everyone. This is very clear that ad hoc, temporary, all these nomenclatures does not necessarily affect this. All are equal.
All right. Thank you so much, Avinash. Thanks for that. Yeah.
Rashish, you wanted to comment?
Yeah, am I audible?
Yeah, you are.
Yeah.
Okay, Acha. Just two things I wanted to say. First, it's not exactly a query. It's particularly a response to the questions made on UPS, and all those who are worried about UPS. I think Avinash will bail me out if I am wrong. The choice which are given to employees at the moment is between NPS and UPS. So at the moment, old pension scheme is not in the radar. That is not part of the choice. Even if somebody has to opt for UPS, the person does not forfeit the right to fight for one's, the eligibility for OPS. Avinash, am I correct?
Absolutely. This is what I also.
Right.
Yeah,
that is the first thing. Second thing is, as far as the choice between UPS and NPS, if push comes to shove, if whatever be the court interventions, legal interventions, whatever we do collectively, if that lingers on, the choice needs to be expedited fast for UPS or NPS. That choice needs to be done very carefully and individually. Means it has to be a case by case basis. There is no one thumb rule as far as NPS and UPS is concerned. I think that's a call which we will take later. As of now, I think after today's session, and Avinash, if you can share, especially the Supreme Court judgment, the relevant judgment with me in particular, because since I am an affected party, I would like to go through each of them. Then what we can do is we can consult a lawyer and we can see, and don't bother about the recess period in court. Whatever we do, in order even to prepare anything, we need at least 2 months.
Yeah. Yeah.
Sorry. So by the time we are prepared with our petition, if at all it is required, that won't happen before August. Let us keep that timeline in mind, and I think accordingly we need to work. And in fact, we need to have more such sessions, and we need to pick Avinash's brain more often to decide on our course of action.
You people are well equipped with this. I just wanted to come and say these small points for clarifying certain things. This is a very good order, which has not only put university at the back foot, they have imposed a cost on the university for misleading the court
Yeah.
and has dismissed the petition. So this is really a time when we must collectively use our effort to do this and get it done.
At the sense, I think some colleague have mentioned the ANDC case. If I'm not mistaken, in the 2023, I think 19 July 2023 judgment, against which the university went to the double bench, which has been dismissed recently on 14th of May. So, in the 2023 judgment, the ANDC case is also listed. It's a 34-page
Ajay Jaiswal versus the University of Delhi, Acharya Narendra.
Yes.
Already part of it.
Yes. So that means even ANDC case by this has been decided?
Yes, absolutely.
So in that case, I think what we can possibly do based on this, we can move. And in the meantime, the specific judgment for ANDC case, since it is listed on 30th of July, that can take its own time and that will come. But we in fact need that much of time to work on this whole petition.
Yeah,
it's quite a long. It's quite.
This also covers another one which is of 2015, and that is of the. I'll tell you about it. Petitioner from. This is. They have not said where. It's of a computer science. Somehow they have not mentioned the college, but this is also another. Rupesh Tehri also is covered in this and others.
Yes.
It's a whole lot of petitioners.
Rupesh Tehri, I think, is ANDC only. Computer science ANDC.
Oh yeah, that's why they might have not mentioned. Yeah, there is two cases, Ajay Jaiswal and then maybe Rupesh Tehri also. Yeah.
Ajay Jaiswal is different. Ajay Jaiswal is not ANDC. I think it's some other college.
No, Ajay Jaiswal is ANDC initially mentioned. That is where, and then he went to Shahid Sukhdev Singh College.
Shahid Sukhdev. Yes.
But initially, his service was in ANDC first.
Yeah. Okay. Maybe possible. Yes.
Avinash, Suhasini is asking, what is the misleading info which DO gave to the court?
Well, it is about a particular case of Ravindra Narayan Mishra, where, he was, let me read it for you. So he was made, he had worked in Satyavati College between 94-95, then he went to Khalsa College between 95 to 2003. He worked as ad hoc, and then subsequently he was appointed as a temporary in 2003, 13th of March, when Ms. Jatinder Kaur, against leave vacancy, whose leave vacancy he was appointed, when she was later actually made permanent as a principal in Bhagat Singh College, he was made permanent there. But and it was written in the survey that because everything has been is done as per the permanent. This was a permanent vacancy, and if she leaves the vacancy, she would be made permanent. Subsequently, what happens is that there was a fresh advertisement in 2005. So university wanted to claim that the appointment of Ravindra Narayan Mishra is on the basis of a fresh advertisement in 2005 when he was appointed in 2006. Whereas the file matter, and this is what Ravindran Mishra argued, that his appointment was, although the 2000 advertisement 2005 does not necessarily makes him permanent because he was made permanent from 2004. So that was already accepted by the university, which when the university produced the document in the court, it was the court observed that it is clear that you have made him permanent from 2004. So where is the question of him being appointed on the basis of a new advertisement comes? So that's the false thing which they were trying to make. That is that. So if you read the judgment and the order of the 19th May 2023, you will get a connection. What is the false information they're trying to make? It's very clear on that. And since university had no other sort of option, they were trying to use this as a kind of a way to appeal it, and that's where the court came very heavily on them.
Thanks for your time.
I'll prepare a draft for that, and I'll share.
Yeah, thank you, Avinash. Thanks, everyone.